Sir, good morning.
Very, very good morning. Very, very good morning.
How are you, sir? Everyone. Today we are meeting for a one-day workshop on Modified Claims Tribunal agreed procedure. This one-day workshop has been structured keeping in view the rules of 2022, which were notified on the 25th of February 2022, which came into force only on 1st of April 2022. And therefore, you can understand and appreciate as to why this particular workshop is being done within the same month when these rules have come into force. In fact, the urgency in regard to this was that the entire procedure in working out the claims under this particular legislation to be carried out expeditiously within a period of 1 year, which would be a kind of a revolution in this particular domain. And for this particular workshop, we have with us this morning Honorable Mr. Justice Midda. Justice Midda had such a rich contribution to make. 26 years into the legal profession, from 1982 to, and in such different domains that he practiced and contributed richly. From 2008 to 2021, 13 years as a judge of the Delhi High Court. And I was amazed the kind of different jurisdictions in which he has played the judicial role. And in each jurisdiction, he has made a rich contribution. This is something unusual. And one really looks into that this kind of a innings that he's played for 38 long years. His passion for teaching, even while being a lawyer, from 1989 to 1992 at the Campus Law Center, that he made his contribution. And post-superannuation, he continues to be as a professor with Galgotias University and making his rich contribution. You know, blending this practical and judicial experience for so many years and coming back to teaching is in fact the rich contribution that Justice Midda is making. And therefore his passion for teaching continues even at this particular point in time. It is not limited to that. The role that he's played in different jurisdictions, he continues to carry that particular role in a far more effective manner into a practical shape that he has given. Sir, so very kind of you to have accepted a request, not only to take this particular session, you in fact structured this particular workshop, mentoring this particular workshop, monitoring this particular workshop. I do not know how should I thank you for doing all this particular contribution. Keeping in view the importance of this particular workshop, we have not confined today's workshop only to our judicial officers from the states of Punjab and Haryana. It is open to across the country, all the different judicial academies. And therefore, this workshop would be first of its own kind, where we have immediately taken the steps. The first session is relating to the new scheme for settlement of motor accidents claims under the Central Motor Vehicle Rules 2022. This would be an overview of those rules and the kind of jurisprudence which is going to emerge in this domain, entirely the brainchild of Justice Midda. May I request Justice Midda to kindly take over.
Thanks for your compliments and good wishes. And I also thank your team for organizing this workshop, which is the first workshop after the new law has come into force on 1st April 2022. I'm feeling very happy and also proud to share my thoughts today. It is a very rare thing that the judgment of the court and the recommendation of the High Court to the government to incorporate in Central Motor Vehicle Rules has been implemented by the central government, and the judgment has become the law today, statutory law.
That's right.
The judgment of Rajesh Tyagi, which was delivered on 8th January 22, had operation only in Delhi, although Supreme Court had directed earlier on 3 occasions to implement the scheme all over the country. But that was not happening uniformly. But with the framing of these rules, the victims all over the country will get the compensation within 6 months to 1 year. You see, road accidents are a human tragedy which involve human suffering, and they impose huge socio-economic costs in terms of untimely deaths, injuries, and loss of potential income. The ramifications of road accidents can be colossal, and its negative impact is felt not only on individuals and their families, but also on the economy. Road safety is an important issue of national concern. Our country has a dubious distinction of having highest number of road accidents in the world. According to the report of Ministry of Road Transport and Highways for the year 2019, 4,49,000 road accidents, which resulted in death of 1,51,000 persons, meaning thereby one road accident every 1.17 minutes and one death every 3.47 minutes, which is highest in the world. The law as it stood before the coming into force of these rules is that whenever there is a road accident, the victim has to file a case, a claim before the Motor Accident Claims Tribunal, and that claim was ordinarily being tried as a civil suit and used to take 5 to 10 years, which is a very huge time. And by that time, many of the victims are not able to sustain that period, and even if they are able to sustain, the money is not relevant from them after 10 years or a later period. So Delhi High Court in the year 2009 started the scheme for expeditious settlement of road accident claims. First judgment came in year 2010, and gradually the Delhi High Court improved that scheme. Delivered was 22nd January 2022. We will come to those scheme, how the law developed at a little later stage. We'll first see what is the scheme. What is the scheme? I will request the Academy to please share the flow chart on the screen so that the participants can have a visual scheme flows. In fact, the note which has been circulated, this flow chart is part of the Central Motor Vehicle Rules. It is also part of the note which has been circulated today, and the flow chart gives a very nice overview as to how this scheme will operate, and will make it very simple. You see, whenever there is a road accident, Yes. This is a flow chart of scheme for motor accident claims. Can it be enlarged a little? थोड़ा सा इसको बड़ा हो सकता है ये? थोड़ा सा. It will give a more clear idea. You see, whenever there is a road accident, whenever the police has to file a first accident report, which is called FAR, in a prescribed form, which is form number 1, before the claims tribunal within 48 hours. And copy of this has to be put on the police website, as well as copy has to be given to state legal services, district legal services authority. So purpose of this FAR is to set the compensation law into motion, like in criminal law, which is set into motion with the filing of FIR. So here also the compensation law sets into motion. And the best part of the scheme is there is no need for the claimant to file a case in a court. Claimant has not to engage a lawyer or file a case. The scheme automatically, the compensation claim which sets into motion with FAR reaches the final stage without requirement of filing any case in the claims tribunal. That is, to my mind, a very important aspect of this scheme. So within 48 hours, the tribunal is aware about the accident. If the police is aware about the insurance, then copy of this is also given to the insurance company so that the insurance company can set into motion. This is step number 1. Now, second step is that within 10 days, the investigating officer has to furnish Form 2, which contains what are the rights of the victims to the victims within 10 days, so that the victims are informed about their legal rights. So that Form 2 is a very comprehensive. We'll come to that form, and I'm not going into the details. The other resource persons will take you to all those details. So Form 2, within 10 days, the victims are made aware as to what are their rights. This is the second stage. Now we come to the third stage. Third stage is that within 30 days, the driver has to submit a form which is called Driver's Form 3. And the owner has to submit a form which is called Owner's Form Roman 4 to the IO within 30 days. So the scheme prescribes that the IO will furnish the blank forms immediately after the accident, when the driver applies for bail, or when the owner applies for supersar, he will immediately first give the form and tell them that please give this form, so that they can fill up and give this form. The object of this is, now this driver and owner's form, this was not there in the earlier schemes framed by Delhi High Court. This is law all over the world. And then we found that the driver and owner in the earlier schemes have not been given any responsibility to disclose their particulars. They are the main stakeholders. Accident has been caused. So driver should declare what is the vehicle number, what is the driving license number, what is the insurance policy particulars, who is the owner, what is the details of the permit or fitness and other details. Similarly, the owner also has to disclose separately in his form as to who was the driver, what is the driving license number, and what are the other details of the vehicle, including insurance, permit, and fitness. So this is stage number 3. Now, after these two forms are submitted, the responsibility has been cast on the police to verify the details of the accident, particularly the driving license. Police has to verify whether the driving license is genuine or not. The police has to verify whether valid insurance is there or not. Police has to verify who is the owner. Police has to verify whether there is a valid permit or there is a valid fitness. And after verification, the police is required to complete this verification within a period of 20 days. And then the police has to submit interim accident report, which is called IAR, in Form 5 with the claims tribunal within 50 days. So this is stage number 4. When now the interim report, the purpose of putting interim report at 50 days is that the insurance company, before they make up their mind whether the claim is payable or not, valid insurance are there or not, the insurance company has to be satisfied whether there is a valid license, whether there is a valid policy, whether there is a valid fitness, whether there is a valid permit, and other details so that they can work on the claim. So, copy of this IAR has to be given to the insurance company, and copy also has to be given to the victims. If you see the flow chart, it contains an arrow on the right side and also arrow on the left side. After this, now the IO will give blank forms, form 6A and 6B to the victims, and tell the victims, in fact, these forms have to be given immediately at stage 2, along with form 2 when the rights are given, that please submit these forms relating to the particulars with respect to the compensation. Now, this also is a new phenomena. In the earlier scheme, no onus was put on the victims. But then again, when we examined the law all over the world, we found that this statement has to come from the victims. If it is a death case, victim has to tell what is the age, income, number of family members, occupation of the deceased. If it is an injury case, then what are the details of the injuries? So this form 6A and 6B have been formulated, and these forms have to be submitted by the victims to the IO. Copy of these forms, upon receipt from the victims, the IO will furnish them to the insurance company. Now, in the earlier schemes of Delhi High Court, starting from 2010 onward, the onus of verifying these particulars was put on the police. But in this scheme formulated in 22, and also the rules which have incorporated, the onus of verifying form 6A has not been casted on the police. So form 6A, with respect to all the relevant particulars, the onus has been put on the insurance company. Insurance company is the state. So they, through their surveyor and investigator, they will verify the particulars and make up their mind how much compensation is payable. Now, then the next thing of detailed accident report. So detailed accident report in form 7 has to be filed by the investigating officer with the claims tribunal within 90 days of the accident. In the earlier schemes, we had in the earlier 4 schemes, the Delhi High Court had fixed the time period of 30 days. But now with the amendment of Motor Vehicles Act 2019, which has come into force on 1st April 2022, the statutory period for filing of DAR has been increased, has been enhanced by the legislature from 30 days to 90 days, and therefore to make the scheme in conformity with the act, the period of 90 days has been fixed. Now, after the copy of this detailed accident report has to be furnished to the victims as well as to the insurance company. Now, within 30 days of receipt of this form, the insurance company has to verify all the claims and make up their mind. And if the insurance is admitted, then they will submit their offer for settlement within 30 days. Now, again, if we come down, now 2 situations can be there. If the insurance company accepts the liability, they will submit the offer for compensation, for which we have framed form 11. And if the insurance company does not admit the liability, they will disclose the grounds on which they want to contest, which is also in form 11. Now, if we come to the first situation, if the insurance company admits the liability and offers the amount which is fair and reasonable and acceptable to the claimants, then the claims tribunal shall pass a consent award, and the time period for passing this award has been kept as 6 months from the date of the accident. Please move the chart little up so that we can see the last paragraph. Please move the chart little upward so that I think last paragraph is not being seen in the flow chart. Just tell them the flowchart upar karenge, I think they are not. So if the insurance company offers the amount which is fair and reasonable and acceptable to the claimants, then the claims tribunal shall pass a consent award and the time period fixed is 6 months from the date of the accident. This is the first situation. Second situation can be if the insurance company offers the amount which is not fair and reasonable, or the claimants do not accept the amount, then the claims tribunal shall hear the arguments on the quantum of compensation, because liability otherwise is admitted, and the claims tribunal shall pass a reasoned award, and the time limit for this has been kept 9 months from the date of the accident. Now we come to the third situation where the insurance company disputes the liability. If the insurance company disputes the liability, then in that case, the claims tribunal has to conduct an inquiry, may have to record the evidence. For that, the time period, further 3 months time has been given, and the outer limit is 1 year or 12 months from the date of the accident. So meaning thereby, now 3 situations are there. First situation, we'll again repeat, 90 days for filing of detailed accident report, 30 days for insurance to submit their response, and so this takes us to 4 months, another 2 months for the tribunal to apply the mind and pass the award. So within 6 months in first situation, the claimant gets the money. Second situation, where amount offered is not fair and reasonable, but the liability is admitted. Now the tribunal need not conduct an detailed inquiry or record evidence. Tribunal only has to hear the arguments on quantum, and for that further 3 months time has been given, and the claims and the case has to be decided within 9 months of the accident. Third situation, where the insurance company disputes the liability. In that case, the evidence may be required, so the tribunal has to conduct an inquiry, and the time period, we now again summarize that the scheme provides for 3 stages, 6 months, 9 months, and 1 year for settlement of the motor accident claim. Now, one can say that this appears to be a very short period, but my view is that for each stage we have prepared the forms. So therefore, all the stakeholders have to just fill up that form and submit. Therefore, the time period has been shown, is to my mind a very reasonable. In fact, prior to January 2022, in the earlier scheme in Delhi, the compensation was being paid within 90 to 120 days, which period now, in view of the amendment of the Motor Vehicles Act, that period has gone to 6 months, 9 months, and 12 months. So this is the scheme which was there in the judgment of 8th January 22, and which has been incorporated as it is in the Central Motor Vehicle Rules. So this is the procedure which has been laid down in the rules. Now, apart from these rules which have come into force from 1st April, now the Motor Vehicles Act has also been amended with effect from 1st April 2022, and this amendment which has come into force, only sections, the central government notified sections 50 to 57 and 93 of Motor Vehicles Amendment Act 2019. The notification was issued on 25th February, and the amended provisions have come into force from 1st of April. Now I'll discuss what are the major amendments. First is Chapter 10, which was earlier no fault liability provisions. They have been omitted from the Motor Vehicles Act 1988, meaning thereby the earlier provisions, section 140 to 144 of the Motor Vehicles Act, are no more in force. Then Chapter 11, which related to the insurance of motor vehicles against third-party risk, has been substituted with new provisions altogether, and the effect of and the summary of that amendment is that, number one, the insurance company has to appoint a designated officer within 10 days of the receipt of intimation of the accident. The object of is very novel. so that the person remains personally responsible for taking the view on the claim. This is section 149 clause 1. Then 149 clause 2, designated officer has to submit an offer for settlement within 30 days of the receipt of the detailed accident report. Then third new provision which has come into force is 149(3)(a), according to which if the offer made by the insurance company is fair, then the consent award shall be passed by the tribunal and the payment shall be made by the insurance company within 30 days. Then 149(3)(b) has also come into force, according to which if the claimants reject the offer, then the claims tribunal shall fix a date for hearing, adjudicate the claim on merits. Then section 150 of the Amendment Act, which has come into force, the duty of the insurance company to satisfy the award in respect of third-party risk. Now, earlier, surprisingly, there was a provision that if an injured dies, if an injured in the accident dies after the filing of the claim, his claim used to abate. And the Law Commission also recommended, and there were the two judgments of Delhi High Court, where Delhi High Court also recommended that the claim of the injured should survive after the death by his legal representatives, because in many cases of serious injuries, the person dies, and even otherwise, a normal person can also die. Now the legislature has accepted that suggestion, and section 156 has been incorporated, and one more 166(5) have been incorporated, according to which upon the death of an injured, the claim shall survive by the legal representatives. Then a new provision has been added, 158, according to which the duty has been cast on the driver to produce all the documents relating to the use of the vehicle. And 158 clause 2, duty of the owner to produce all the relevant documents. Then 159, this is the provision which I was referring to. 159 has extended the period for filing of detailed accident report, which prior to the amendment was 30 days, accident information report, 158 clause 6. But now that period has been extended to 90 days. And because of this amendment, we had also extended and made the scheme of filing of detailed accident report within 90 days, which has now been incorporated in the rules. And therefore, we had taken the first period to 6 months. Then section 160 has been incorporated, which casts a duty on the registering authority and the police to furnish the particulars of the vehicle involved in the accident to all the victims. Then very important provision has come with respect to hit and run accidents. In hit and run motor accidents, the compensation amount has been enhanced from 25,000 to 2 lakh in death cases and from 25,000 to 50,000 in grievous injuries cases. Then 162 incorporates a provision, a scheme for golden hour, that golden hour which is considered to be 1 hour following the traumatic injury, when there is a highest likelihood of a person death being prevented. So it provides for a cashless treatment to the victims of road accident in the golden hour. It is a very important provision and will go in a long way. Now 164, as we discussed earlier, no fault liability chapter has been omitted, chapter 10, but section 164 has come into force. According to, we had a schedule. Now that schedule has been dispensed with. It has been omitted from the act, that second schedule, by virtue of section 93 of the Amendment Act. And now fault liability, if the in cases where the injured or the person who died himself was negligent and he does not have the proof, then the family members can still bank upon 164 to claim 5 lakh in death cases and 2.5 lakh in injury cases. But the restriction on invoking this is that upon receipt of this amount, now a person cannot file a claim under 166 to claim a higher amount. 164A empowers the government Now, earlier there was a provision for payment of interim compensation. Now, under the new law, there is no interim compensation. If a person opts for no fault liability, he has to accept 5 lakh in death cases and 2.5 lakh death in injury cases, and that is the end of the matter. The matter will be closed. It is not an interim amount; it is the final amount. On the other hand, if he does not accept this no fault liability and he seeks to claim on merits, then he will have to go by the scheme which we discussed earlier under the rules. Now, 164B is a very important provision. It is a motor vehicles accident fund. Now, this was recommended by Delhi High Court in my judgment in 2010 and 11, and also by the Supreme Court at that stage. And in those judgments, the Delhi High Court examined the law in South Africa. In South Africa, there is no need to take an insurance. All the vehicles are deemed to be insured, and a cess is taken on the petrol and diesel, and that cess goes to the road accident fund, and from that road accident fund, the money is paid to all the claimants. So in the judgment of Rajesh Tyagi, the Delhi High Court noted that there are approximately 39 to 40% vehicles in our country which are uninsured, and the government has not been able to control the menace of the uninsured vehicles being on road. So the court recommended that if the government is not in a position to ensure that all vehicles on the road are insured, they may consider adopting the South African model for creation of a road accident fund by imposing a cess on petrol and diesel. In a subsequent judgment, the High Court also considered the Canadian model, where a cess is also taken one time at the time of registration of a vehicle, and also from the driving license. Whenever a driving license issued, then also money is collected from the driving license, and also at the time of renewal, which also goes to road accident fund. Now, the Supreme Court in Jayaprakash also took note of the South African as well as Delhi High Court judgment, as well as Canadian model, and recommended to the government to create a motor accident fund. Now, this is a very good development that the government accepted the recommendation of Delhi High Court and the Supreme Court in Jayaprakash matter. And in 164B, the government has constituted a motor vehicles accident fund for providing compulsory insurance to all the vehicles. Now, this fund shall be utilized for the purpose of treatment of the injured in the road accident, as well as compensation to the representatives of the person who die or sustain grievous hurt in hit and run accident. 164B empowers the central government to prescribe the compensation to be paid to such persons out of the fund. 164C2W empowers the government to make rules with respect to the persons to whom compensation may be paid. Maximum liability amount in such cases shall also be prescribed by the central government. Then one more new provision which has been incorporated is 164C, which empowers the central government to make rules. Now, by virtue of 164C, the government has framed the Central Motor Vehicle Fifth Amendment Rules 2022, which we have discussed before this. Now, prior to the amendment, prior to 1st April, there was no period of limitation for filing a claim, but a new provision has now been added, 166(3), which prescribes a period of limitation of 6 months for filing of the claim application. Now, a question has been asked by many persons as to what is the position whether this will also apply to the filing of the DAR. My view is that if a person files a claim, then he has to file within 6 months. But if the police delays the filing of the DAR and it is also filed after 6 months, then there is no bar in that filing of the detailed accident report, because the detailed accident report has to be treated as a claim petition by the court. So this is only with respect to filing of the claim by the injured or the LRs of the dead person. Then there's one more provision, 173(2). No appeal in case the award is less than 1 lakh rupees. So these are the amendments to the Act, Motor Vehicles Act, which have come into force. on 1st April 2022. And then on 1st April, Central Motor Vehicle Rules, 5th Amendment rules also have come into force. Now we'll once again recapitulate the rules and then we'll discuss how this law has developed. So again, coming back to the stages, to my mind, this procedure which was incorporated, framed by Delhi High Court, before framing this procedure, we had examined the law all over the world. And my view is that this law which is there, this is the finest accident law in the world. Now, the things are so simplified, and for every stage there is a form. So within 48 hours, the IO has to submit first accident report with the claims tribunal with copy to insurance company. Then within 10 days, Form 2 has to be given to the victims so that they are aware of their right. IO will also give Form 6A and 6B to the victim, which they have to file within 60 days. Immediately on the accident, the IO will give Form 3 to the driver and Form 4 to the owner and instruct them to submit the form within 30 days. So within 30 days, we'll have driver's form and owner's form. Upon receipt of this, the police will verify the driver's form and owner's form within 20 days and submit interim accident report within 50 days. Object of this is that the insurance company will start working on it only after there is a valid license, valid insurance, valid permit, valid fitness. So therefore, this is to enable the insurance company to start working to find out whether the liability is admitted or not. Now, after this, the victims have to file Form 6A and 6B within 60 days of the accident. Copy of this form has to be given to the insurance company, and the duty to verify Form 6A is only of the insurance company, not of the police. Whereas Form 2 and 3 of the Form 3 and 4 of driver's form and owner's form, the duty has been cast on the police to verify the forms. Whereas Form 6A, which relates to the computation of compensation, the main stakeholder is the insurance company, and the insurance company has to verify that forms and respond to the court. 90 days before the expiry of 90 days, the police has to submit detailed accident report with the claims tribunal. Scheme also says that the police has to complete the investigation of the criminal case also within 90 days. So after the filing of detailed accident report, copy has to be furnished to the insurance company, and the insurance company has to submit its response within 30 days of the receipt of the DAR. And the insurance company additional duty which is there, whenever the intimation of the accident comes, for example, if the intimation comes on the filing of the first accident report, then within 10 days the insurance company has to appoint a designated officer. That designated officer by name has to submit his response in the prescribed form before the tribunal. That form is form number 11, in which he has to not only say how much money the insurance company is willing to pay, they have to give the reasons for it and a detailed calculation. If the insurance company admits the liability, then a consent award shall be passed and the proceedings have to be closed within 6 months. If the liability is admitted but the amount offered is not fair, then the tribunal will hear the arguments on quantum and pass a reasoned award within 9 months of the date of the accident. And the last situation where the insurance company disputes the liability, in that case, the claims tribunal has to conduct an inquiry and pass a award, and the time limit for that is 1 year. So, and for every stage there are the forms, and thereafter for the rules also contain a form of written submissions to be filed by both the parties before the claims tribunal. It also contains the form which has to be incorporated by the claims tribunal in its award. It also contains the forms of the compliance by the claims tribunal. So therefore, coming back to it, this scheme has got 3 stakeholders. First stakeholder is the police. Police has to make this scheme successful. The first stakeholder is the police. So police, the role of the police is, number 1, immediately on the accident, when they have to file first accident report within 48 hours. Then they have to give Form 2, Form 6A and 6B to the victim and tell them and collect the collect the Form 6A and 6B within 60 days. They have to furnish the Form 3 and 4 to the owner and driver and collect that form from them within 30 days. Then the police has to verify Form 3 and 4 and submit interim accident report within 50 days. And then they have to close the criminal case within investigation of criminal case within 90 days, and then detailed accident report within 90 days. So this is the role of the police. So, but if the police fails in its role prescribed in the rules, then the second stage will not arise. Therefore, to make this scheme successful, the police has to gear up and give appropriate training to all their officers so that this scheme is successful. Now in Delhi, when we initially started our scheme in 2010, then the Delhi police gave a very vigorous training. They prepared a training manual for the police officers, and training was given. Only then the scheme took the headway. So therefore, my request to all the police officers who are present here today is to properly take training manual and give training to all their police officers so that the first stage is completed without any delay. If the police completes their role within the time limits prescribed, then the second stakeholder is the insurance company. Their role is number one to appoint a designated officer within 10 days of the receipt of intimation. Number two, immediately when they receive Form 6A, they will Form 6A from the police, and then they will appoint their own surveyor and investigator. They can do it earlier also, and they will verify whether liability is admitted, whether driving license is there, and if the liability is admitted, then what amount the claimant is entitled. And within 30 days of the receipt of detailed accident report, they have to submit their response in Form 11 to the claims tribunal. If the police completes their role in time, then the second stakeholder is the insurance company, who have to complete their work in these timelines which we have discussed about. But in a case where police completes the role but the insurance fails, then also the scheme. The second situation for the insurance officers to give training to all their people, how to compute the compensation, how to give the reasons. They have to select and identify the designated officer which they will be appointing in road accident matters, and all those designated officers should be given proper training on the motor accident claims law, so that the stand taken by them is fair and reasonable and passes the test of the judicial review. Now, if the police completes their role and then the insurance also completes their role, now let's assume police has completed FAR in time, given the forms in time, collected owners and driver forms in time, filed IAR in time, filed DAR in time, and then insurance has filed Form 11 within 30 days. Then the last stakeholder is the Motor Accident Claims Tribunal. So Motor Accident Claims Tribunal has to find out in which category this case falls. If it is the first category where insurance is admitted, amount offered is fair and reasonable, then a consent award should be passed immediately, and the award should be passed, and the outer limit is 6 months, which means 90 days for 3 months for DAR, 1 month for insurance response, and 2 months for the tribunal. Second situation, where the insurance admits the liability, but the amount involved is not fair and reasonable, the tribunal will hear the arguments and pass the award, for which additional 3 months have been given. So within 9 months, they will pass the award, and 3 months, to my mind, is a very fair and reasonable period. Third situation, where the insurance company disputes the liability. Now, in that case, the evidence may be required and an inquiry is required in terms of the provisions of the Motor Vehicles Act. And for that, further 3 months time has been given, and the tribunal should pass the award within thereby 3 months more. But if the police completes their role in time, insurance also completes their role in time, but the tribunal now faults, then also the scheme will fail. Many cases have come to our notice here where both the parties had completed their role in time, and now the tribunal fixes a date after 4 months, 5 months, even in a stage 1 and stage 2. There also the scheme fails. So therefore, all the motor accident claims tribunal also should gear up, and the Judicial Academy is doing has taken up a very fine task of taking up this first workshop, so that all the judicial officers here who are participating, they can for all stages. So therefore, this is a very rare situation where the forms prescribed solves much of the problem which otherwise we face in normal civil and criminal and other jurisdictions. So therefore, my view is to make this scheme successful, the police, the insurance company, and the the claims tribunal have to gear up to do it. Now, in order to make the scheme successful in Delhi, a compliance phenomena report to be filed by the claims tribunal, monthly report with the Registrar General, to place on record how many cases came up and how many cases the police complied with their role, how many cases police complied but insurance faulted, and in how many cases both of them complied and the tribunal failed. So that report should be filed with the Registrar General, and where the Registrar General finds that something is lacking on behalf of the tribunal, then it will be sent to the ACR committee of the tribunals. So this check mechanism also has in Delhi has proved, because this new rules which are coming into force from 1st April is for all over the country. But so far as the Delhi is concerned, this scheme is already working since 12th of January 22. And today we have got the Delhi State Legal Service Authority also. They will explain how they have taken forward this scheme. So with this, we have covered what are the amendments to the Motor Vehicles Act, what are the new rules, what is the new law which has come into force from 1st April. Now, details of the scheme, they will be taken up by, we today have a resource person who will take up the role of the police. They will deal with the forms and what information is required in those forms so far as police is concerned. We also have a resource person for the insurance company who will explain how the insurance company will deal and what are the details of those forms. And today we also have District Legal Service Authority who will deal with the role of the claims tribunal in making this scheme successful. So I'm not going into the details which will be taken up by the respective resource persons. Now I come to the second stage which I discussed earlier as to how this law has developed. See, it is a proud moment for me, because the judgment of Delhi High Court, authored by me, has been accepted by the government and has been made a statutory law which has come into force. But I would like to share how this journey started. In 2009, when I on 1st January 2009, when I was first sat on the MSCT roster, then I noticed that 5 to 10 years are taken by the in a motor accident claims tribunal for deciding of a case, and it may even take longer. Then I found out what are the reasons why the delay is taking place. Then the reason for delay was that, first of all, most of the victims of road accident are poor people from the lowest strata of the society, and they have no legal advice available to them, and most of the times they are chased by the ambulance chasers, and a case is filed, which at times the case is also not but a half-baked or whatever worth it is, a claim petition is filed by the ambulance chaser. Now, once this claim petition is filed, then the notice is issued to the driver, owner and insurance company, and the service of driver and owner itself used to take at times 2 to 3 years, or at times even more. So the case would not proceed and remain just lingering at the stage of service. Then third delay reason was that even after service, then it took time for completion of pleadings, and after completion of pleadings, then the eyewitness notice issued to the summons are issued to the eyewitness to be examined on oath, and the service of the eyewitness is at times not possible, or it is grossly delayed, which further delays the matter. And last reason for delay was that the Motor Accident Claims Tribunal were conducting the claim petitions as a civil trial, whereas the Motor Vehicles Act uses the word inquiry, not a trial. In a judgment of Mayur Arora of Delhi High Court, I have discussed what is the difference between inquiry and trial. You see, in a trial, normally the court does not interfere with the pleadings or the evidence of the parties. The court gives complete freedom to both the parties to do whatever they want to do and does not interfere and then decides the matter. But in an inquiry, the judge sits on the driving seat and is duty bound to reach the truth, irrespective of the failure of the parties to lead evidence. And the best example, there is a judgment which again is reported in the Motor Accident Claims Referencer and Mayur Arora judgment, where there was a death of a small child, 5-year-old child of a laborer, and when the parents filed the claim petition, so the insurance company disputed that please prove this child were your child. Now those people did not have any proof, and the claims tribunal dismissed the claim petition, saying that no proof has been shown as to this was their child, and they may have picked up some child and some dead body to claim the compensation. Claim petition was dismissed. When the matter came in appeal, the High Court took the view that this is not a trial. This is an inquiry to reach the truth. So the court, appellate court, in appellate jurisdiction, directed the SDM to conduct an inquiry and find out whether the child was there or not. SDM went there and conducted the report. They said, examined all the witnesses, and they found this child was born to those parents, was living with them. When he was injured and his leg was amputated, the parents were in the hospital, but they were poor parents. They didn't have any document. But SDM placed on record extensive evidence to show that the child was of those parents. So the court laid down in that judgment the principles, what is the difference between inquiry and trial, and what is the duty of the judge to reach the truth. So there the court has laid down extensive principles on the duty of the court to search the truth, and extensively use section 165 of the Evidence Act, which empowers the court to examine any person, whether a party or not, at any stage, and ask any question, whether relevant or not, provided that the judgment shall be based only on facts declared by the Evidence Act to be relevant. So 165 in Rajesh Tyagi matter was extensively used, and the Supreme Court in Jayaprakash affirmed Delhi High Court view in Rajesh Tyagi and said that 165 should be extensively used by the Motor Accident Claims Tribunal to reach the truth. So in 2009, when I noticed that all the claim petitions are just lingering in courts, and most of the people who die in road accidents are poor victims who want the money immediately. They can't wait for 5 to 10 years. After 5 to 10 years, the money would not be required by them. Many of them may not be able to sustain that period. So then during that period in 2009, there was a delegation of judges from UK and in Delhi High Court, and I asked them, I said, what is the law in your country on motor accident claims? They said, there's no law. I said, no law means what? They said, whenever there is an accident, insurance company will, in 1% of the cases where the claimant is not satisfied, he can approach the court. So when I heard this and then I examined the position in our country in claims other than motor accident claims, you see, if there is a fire in a factory, or there is a theft loss, or there is some other loss, then there is no need to file a case. When there is a theft or fire, the insured person intimates the insurance company. Insurance company immediately sends the surveyor. They assess the loss and intimate the person. And if the person is satisfied with that claim, then the money is paid. And some people who are not satisfied, they can go to the civil court or consumer court to make the claim. But so far as motor accident claims are concerned, Since Motor Vehicles Act says that the award of the claims tribunal is necessary, so therefore it is mandatory for a person to approach the claims tribunal and get an award before getting the money. But if you see the number 6 lakh accidents in a year, so meaning thereby 6 lakh accidents, 6 lakh cases filed in 1 year, and 5 years it is 30 lakh cases. We don't have so many number of judicial officers. We don't have that paraphernalia to decide those 30 lakh cases as an ordinary civil suit. Therefore, there was a need to evolve a method by which the claimant gets the money by a automated system. And then the judges from UK said that in all cases within 90 to 120 days, the money is paid. Then second situation which came to my mind, there was a person, it came to my notice that a person had gone to Canada where he met with a road accident and suffered injuries. He was admitted to a hospital and the police intimated the insurance company that, look, the vehicle insured by you has met with an accident. Insurance company immediately sent their officer to the hospital and the officer recorded the statement of the medical superintendent, examined the medical record, and the medical superintendent said that about $5,000 would be spent in the treatment over 1 week or 10 days. So he prepared a check of 6,000 and gave it to the person within 1 hour after visiting the hospital. So the case was over. So I considered the need to frame a scheme where the people get the money in 90 to 120 days. So in 2009, I constituted a committee of Secretary Law, Secretary Insurance, Police Commissioner, all the 17 insurance companies at that time. I said, you please all sit together and you please frame a scheme by which the victims get the money within 90 to 120 days. That committee did a wonderful work and they prepared a scheme. The committee reported that if the police is the first agency which registers the FIR and in a road accident matter. So if the police, after registering the FIR, they conduct an inquiry into the parameters which are required for compensation and submit a detailed accident report instead of accident information report prescribed in the Motor Vehicles Act 88, then within 30 days insurance will submit the response and within 30 days the tribunal should pass an award and 90 days the award should come and 30 days the payment. So within 90 to 120 days the victim will get the money. So when this report came, so this court, the High Court requested the police to do an additional work of filing a detailed accident report. So police were reluctant. Police took the stand that, look, we are the authority under the CRPC. So we are required only to do our duties and conduct whatever duties are given under the CRPC and the other criminal laws. But the police is not required to collect the material relating to the compensation or a civil matter, which is in the purview of the claims tribunal or the civil court. Now, in the meantime, one more situation arose. The Motor Vehicles Act was amended in I think 97, and Section 158(6) was incorporated. Section 158(6) said that whenever there is a road accident, the SHO will file a accident information report prescribed in Rule 150 of the motor vehicle rules with the claims tribunal within 30 days of the accident. And in the same amendment, 166 clause 4 was also incorporated, which stated that the accident information report shall be treated as a claim petition by the claims tribunal and he will try that case. Purpose of this amendment was that the compensation law sets into motion the criminal law which sets into motion with filing of FIR, the compensation law sets into motion with filing of AIR by the police within 30 days, and claims tribunal will treat as a claim petition, so that automatically with the filing of AIR, automatically whether the victims prefer a claim or not, the compensation law sets into motion. Now, this provision which was incorporated, a PIL was filed in Delhi High Court, and Justice Y.K. Sabharwal was the Chief Justice at that time. And in that PIL, it was pleaded that the police is not filing AIR. So when the report was called from the police, the Delhi police took the stand that, sorry, we were not aware that such a provision has come. Now we have noted and we have issued a standing order. Henceforth, whenever there is an accident, we will file the AIR within 30 days. So matter was closed after recording their undertaking. Then 99, two more PILs were filed, saying that the police is still not filing AIR. When these two petitions came up before Delhi High Court, Justice Pasayat was the Chief Justice at that time. So notice was issued to Delhi police, and the Delhi police took the stand that, look, we are filing AIR in all the matters. So the Chief Justice also called for a report from all the tribunals at that time, and all the tribunals submitted a report that they are not receiving AIR at all. At times, only copy of FIR is sent. So Chief Justice took a very serious view that the FIR cannot be treated as a claim petition. It is only AIR. So a warning was given to Delhi police that henceforth, please file the AIR in the prescribed form in Rule 150. And the second and third two PILs were also closed. Then a third matter was filed by General Insurance Council in Supreme Court in 2006. And by that, and it was at that time before the Supreme Court, it came up before Justice Pasayat. And the Supreme Court took a very serious view and said that henceforth, if AIR is not filed in any matter, then the Joint Commissioner shall remain responsible and he will be held responsible. So, and if there is a failure of SHO, then in that case, the Joint Commissioner shall remain responsible. So 2009, all these four matters came to my notice and issued a notice to Delhi police saying that after 2006, last 3 years, from 6 to 9, after the Supreme Court gave the direction, said, please file the data, whether it is being complied with, and give the data as to how many accidents took place and in how many cases the AIR was filed within 30 days. So in response to this notice, the Delhi police filed a affidavit saying that 13,000 accidents took place in 3 years, and in all the 13,000 accidents, the AIR was filed within 30 days with the claims tribunal. Simultaneously, I had also called for a report from the claims tribunal. There were 12 claims tribunal at that time in Delhi. So all the 12 claims tribunal submitted a report saying that they have not received a single AIR. And a false affidavit has been filed by the police. So upon receipt of the report from the tribunals, I issued contempt notice to all the SHOs in the last 3 years and all the joint commissioners in terms of the Supreme Court judgment who were responsible. So, no, there was some communication gap, somebody wrongly informed. So now we will do it. So this matter was pending. So coming back to the stage when the Delhi police took a stand that they will not take up the additional duty of collecting the information relating to compensation and they will not file detailed accident report. So then the court took the view that all right, then let all the contemners remain present in court tomorrow. Now that contemners for 3 years, all the SHOs and joint commissioners included practically the whole of the senior Delhi police officers. So the commissioner for police at that stage took the matter quite seriously, and then the standing council requested the court for some via media. So I suggested, all right, without prejudice to your contention that you are not liable, and on the suggestion of the court, as a pilot project, you please do it for 6 months. So they found this via media quite satisfactory, and an undertaking was given by the police that without prejudice to their rights, that they are not required to collect this information submitted by the committee, and on the suggestion of the court, on a trial basis, just as a pilot project, they will agree to do it from 6 months. So then this scheme, the scheme was issued on 21st of December 2009, and which was implemented from 1st April 2010. 6 months time was given to the police to train their officer, issue a manual, issue standing orders, because that was a new thing which was required to be done. And on 1st April, this new scheme took into place by virtue of the judgment of Rajesh Tyagi of 26th December. And now in this scheme, the police had to file detailed accident report instead of AIR prescribed in the law within 30 days. The insurance has to submit the response within 30 days. and the tribunal has to pass the award within 30 days and money within 30 days thereafter. Second important feature was that when the detailed accident report is filed, the IO will produce the driver, owner, claimant, eyewitness, as well as insurance, so that the issue of service delay because of service should not remain pending. So from 1st April, this scheme came into force and the police started filing detailed accident report. And on the date of filing of DAR, the IO produced driver, owner, claimant, eyewitness, and insurance. So no issue of service. So in first 1.5 years, there were about 21,000 accidents in Delhi, out of which I think 11,000 in Jayaprakash judgment 13th May 2016 directed all the states to implement this procedure all over the country. In the meantime, the Delhi High Court further improved the scheme. In the first scheme, the forms were not there. So then the Delhi High Court found that without the forms, different reports were being filed. There was no uniformity. So therefore, Delhi High Court modified its scheme in the scheme, and in the second scheme, the Delhi High Court also incorporated the forms for each stage. Then the second judgment, which was issued by Delhi High Court, which is Rajesh Tyagi 2, then the Supreme Court in a subsequent matter, again in Jayaprakash, noticed that the Delhi High Court has modified its earlier scheme. So the Supreme Court directed the Rajesh Tyagi 2 to be implemented all over the country. In the meantime, Delhi High Court also kept on further improving. And the third judgment, Rajesh Tyagi 3, came into force in 2018, in which the Delhi High Court further improved upon its earlier schemes. And the Supreme Court, in the third judgment, which is M.R. Krishnamurthy, in 5th March 2019, took notice of the third judgment also and directed all states to implement the modified scheme of Delhi High Court. So that third scheme was also implemented. In the meantime, the Delhi High Court noticed that all these schemes which are developed, they have been developed just on our own understanding of the subject and on experimental basis, but we have not examined the law all over the world. So then in 2020, then I took note of the law all over the world. So in the last judgment, we have taken note of all the law all over the world. Then also we noticed that Ministry of Surface, Road and Transport also conduct a survey on annual basis, on the basis of which they submit an annual report, how many accidents took place. The purpose was different, but they had also very nice forms. So this court also issued notice to the Ministry of Road Transport and Highways, and the Road Transport Ministry also assisted. And then after examining the law all over the world, this court, High Court, noticed that all over the world, the form is also called from the driver, form is also called from the owner, and form is also called from the victim. And driver and owner's form have to be verified by the police, because if there's no driving license, then it is an offense. If there's no insurance, it is an offense. And therefore, then this court modified the 8th January judgment in toto, and a new scheme was incorporated. And in that scheme, now the scheme which we have discussed today, which is now part of the rules, came into force on 8th January 22. So with this, we cover the aspect as to how this law has developed, how this law. So you will, to fully understand this scheme, to my mind, the participants may have a look at the judgment of 8th January, which will give a detailed reasons how we have done, why we have done, from where we have picked up what. And to my mind, the law which is this Central Motor Vehicle Rules is the best law on the planet today for motor accident compensation. And to my mind, many of the we had a communication with the other countries may amend their law to incorporate this law in their motor accident compensation. So with this, now I have taken you as to how this law has developed. Now I come to the last leg. We are already, I think, running against close to time. Now we come to the last leg. What next? Can something be done better than what more can be done for this. Now, one view which I always took for many years with many insurance companies was that where a person dies on the spot, if the intimation is given to the insurance company immediately at that time, and the insurance company reaches the spot, dead body is still lying there, vehicle in accidental condition is there, eyewitness is there. At that stage, the insurance company can immediately verify whether negligence is there or not. The insurance company can see the dead body to verify, to satisfy that the person has died. They can see who are the family members who are doing the cremation, what was the age of the person. They can verify the documents. At that stage, nobody will fabricate or create a document to show wrong age or wrong income or wrong occupation. How many LRs are there? For death, we have to only see three things. One, negligence. Two, what is the name, age, occupation, income, and number of family members. This can be done if we reach the spot immediately. It can be done immediately within 10 minutes. And then compensation can be calculated and paid to the person on the spot, like we had calculated in a Canadian model, Canadian example. So many years I told the insurance company, I said, you please, and I told the police also, I said, you please inform the accident immediately, and insurance surveyor should reach the spot. I said, if you are able to provide a case, I can also come there on the site. Everything we'll do it there and then, and we can pay the money. But the insurance company was not very excited with this suggestion. This suggestion I was giving for the last, I think, 7-8 years, from 2013-14 onwards. Many of the orders of Rajesh Tyagi incorporate this suggestion. But finally, in the judgment of 8th January 22, I incorporated this in the order. Insurance company was not agreeable, so I said, all right, you agree to do it for a pilot project for to start with in respect of one police district. They agreed to that. So in 8th January 22 order, we started a pilot project. We said in this particular district, if there is a death case, then IO will, then we created a GIC, General Insurance Council cell, to add a nodal officer. So whenever there is an accident, you please inform that cell. That cell will inform the insurance company. The surveyor of the insurance company will reach on the spot, and there they will verify the negligence, age, income, LRs, occupation, and calculate the compensation. And the money should be paid before the 13th day ceremony, Tirni ceremony of the deceased. So this pilot project came in 2022. On 1st May itself, in the morning at 4 o'clock, a person was in Vasant Vihar, Delhi, New Delhi. A person was driving his car. His relative was in the hospital, so he had a small nap. So he could not notice a barricade outside the police post. So hit the barricade, and a police constable standing on the barricade, he died because of the accident. So immediately FIR was registered, and the intimation came. We have Mr. Kamalji Arora here, was part of it. Even Mr. SP Jain, Council of Insurance Company, is also here today. He will also share his views. And immediately intimation was given to the insurance company, Bajaj Alliance Company. And within 3 days, the IO filed the detailed accident report with the claims tribunal. Within 3 days, next 3 days, the insurance company submitted their response and offered a compensation of 36 lakh rupees, which was totally according to the principles of law, and they gave the detailed breakup. Within 3 days thereafter, 9th day, the claims tribunal held a special meeting of Special Lok Adalat where this a award was passed. Oversee that this scheme goes further, and I'm told many of the insurance, particularly I think Bajaj Insurance Company, has taken up this further, and in many cases they have taken up the such cases where they immediately reach the spot and verify all the details and offer the fair and reasonable amount, and we don't have to date. So the rules which give 6 months Time. So one last thing I will share. One thing which was very painful to see was that the money which was awarded by the court, which was awarded by the court, was taken away by the by the middleman, and ultimately the money which comes to the hand of the claimants was very low and negligible. So, and then the court noticed how the modus operandi was operating. So modus operandi was when the check is released, then at times the check is deposited in some joint accounts of the victim with some other third person. And then the second most modus operandi was person. Third was if FDR is issued, then to keep the original FDRs. Fourth was that to have a debit card or ATM card issued from the victim. So all these things came to the notice of the High Court. It constituted a scheme for the dispersal of motor accident claim compensation. That scheme was in the earlier judgment, 2018 judgment, which is 2018 judgment contains that scheme, and that scheme also forms part of this rules now. Now, under that, this is called modified scheme. Now, under this scheme, the court directed that whenever a compensation is deposited by the claims tribunal. Sorry, before that, the High Court directed, and which is part of here only, that whenever the claimant files their Form 6A, at that stage, they will disclose the particulars of their savings bank account, which should be individual bank account, not a joint account. And the endorsement should be taken from the bank that no checkbook or debit card shall be issued on this account. Now, this particular that scheme, which has been operational by 21 banks, now the check can be deposited only in the savings bank account of the victim, in which no checkbook or debit card is to be issued by the bank. Victim can withdraw by the withdrawal form by personally visiting the bank. Then the scheme also casts a duty on the tribunal that whenever there is a, let's assume there is a award of 10 lakh rupees, the court will examine the claimant to find out what is their financial needs, whether they are staying in a rented accommodation or their own house, how much are their expenditure, how much the deceased was earning and contributing, and then on that basis, they will decide how much money per month is required by the claimant. For example, we have given the examples also there in 21st January, 8th January judgment, that if the award is for, say, 10 lakh rupees, then the court may release 1 lakh rupees by transferring or issuing a check to be deposited in the savings bank account. Remaining line 9 lakh to be kept in say 90 FDRs or 90 FDRs of 10,000 each or 100 FDRs of 9,000 each for the period 1 month, 2 months, 3 months up to 90 or 100 months. And these FDRs, no original FDR will be issued. Original FDR will remain with the bank, and the bank will transfer and or credit the amount directly into the savings bank account of the victim every month, so that the person gets the money every month, and the money keeps on increasing because the interest will increase. For example, there are 100 FDRs of 9,000 each. So first month the person will get 9,000. Next month he may get little more, and then finally at the end of 100 months, that 9,000 will become approximately 14 to 15,000 per month. So this will take care of the inflation. The next thing which is provided in the scheme is that the savings bank account of the victim should be near the place of the residence. Normally, what was happening earlier in Delhi, that the account was opened in the court complex. For example, it is a district court, Tisjari, Delhi. Then the account was opened in State Bank of India, Tisjari, and the victim who is staying in Bihar had to come every month to withdraw the money. So court said no. Then the victim remains under the influence of the middleman. So court said no, the account should be near the place of the residence. So if the victim is staying in Patna, account has to be in a nationalized bank in Patna, and the court will transfer from here 10% there in that account, and every month State Bank of India, Tisjari will transfer 9,000 debit card. So this scheme also is operational, and to my mind, as we have discussed earlier, even if the police does all their work, even if insurance also perform their duties, if the tribunal also passes the award in 6 months, but if the money is not protected, then everything is multiplied with zero. Therefore, it is duty of the court to protect the amount from being wasted. And this first scheme which Delhi High Court framed in 21st December 2009, which was affirmed by the Supreme Court in Jayaprakash judgment, takes note of the scheme formed by Delhi High Court. Although initial scheme was a quite primitive 2019, which is M.R. Krishnamurthy, the Supreme Court took note of the last scheme which was framed by Delhi High Court and affirmed that this Macard scheme contained in 7th December 18 directed all the 21 banks to implement the same on all India basis. So this scheme has been framed by Delhi High Court. 21 banks in the country, nationalized banks, have opened a special scheme in their Macard scheme. So tribunal has to only direct that please invest the money in the Macard scheme according to these amount can be given, and that scheme automatically has got a inbuilt portfolio that no checkbook, no debit card, near the place of residence, and no FDRs to be issued, and money automatically will transfer to the account. In fact, one more issue which I took up very vigorously at different stages twice. I called the Reserve Bank and all the banks. I said to the motor accident victims, you please pay 2% more like you pay to senior citizens. I said, these are the people who, because of their no fault of theirs, and most of the time sole breadwinner goes. So I called Reserve Bank also. I called the senior government officers also. I called Finance Ministry also, Law Department also. But despite my best efforts, I did not succeed. And the banks did not agree to give a high rate of interest. But I still hope at some stage, these are the more deserving category, even as compared to senior citizens. If let's take a small society where let's assume one person has to die every day, then it is duty of society also to ensure that the family is able to sustain on the planet. It is not only that we keep closed eyes. In fact, in one of the lectures, I also compared the data as to how many people die of unnatural deaths, how many people die of the diseases. The number of deaths which take place because of the road accidents is still the highest. Just think it over again. 6 lakh accidents in 1 year and 1.5 lakh deaths. In my last lecture, I was also comparing with COVID. Maybe COVID has taken ahead of this, but can it be said to be a lesser evil? And what are we doing? So I think this is a good food for thought. We have shared the new rules. I have shared the amendments in the Act. I have shared how the law developed. I have shared what is the next stage to which Delhi High Court had gone, which is still not part of the law, but in Delhi. But any other High Court or any other tribunal can take up this, and in a given case, they should do it. And my request to Dr. Balram Gupta would be that the monthly report by the tribunals to the High Court should be made mandatory in your High Court also. Otherwise, the scheme will fizzle out, and we will not be able to control and even find out who is at fault. So that performa of that compliance report is also there in this scheme. So all the participants may have a look at 8th January judgment and then 12th May judgment and then the rules. The reading of the three will give them a fair idea what is the object behind it. And one thing more I always shared with the judicial officers. You see, the motor accident claim jurisdiction is the easiest jurisdiction. You see, let's take a death case. Now, death cannot be faked. Most of the time there is a proof. Number of family members cannot be faked. Income also most of the time there is a proof. If there is no income, we go to minimum wages. So at the end of the day, what are we? The case for recovery and the other denies, and both the sides give contrary witnesses which withstand cross-examination. Is it easy to reach that conclusion? Or in a criminal case where there are so many doubts created, is it easy to do it? But for a motor accident claim compensation, jurisdiction, jurisprudence is the easiest jurisprudence. So, and Dr. Balram Gupta will confirm. Justice Kannan in Chandigarh, in Punjab Haryana High Court, on MSCT jurisdiction, he used to decide about 100 matters in a day. That time I was also on MSCT jurisdiction. I tried to match his speed, but I could not. But on the other hand, I concentrated on developing the law. So that took more toll. And my advice to Motor Accident Claims Tribunal here is that the award need not be a lengthy award. It is an inquiry. If you see, other than the judgments where I have developed the law, other judgments, the judgment has to be kept simple by just verifying and satisfying on negligence, age, occupation, income, and an injury case on injuries, nature of injuries, expenditure on injuries, disability, loss of percentage, which is not a very difficult thing to do. So, and Justice Kannan had prepared templates for different categories of cases, for death cases, for injury cases, death of a widow, death of a child, death of a other person, and then he will take up the matter, categorize those cases, and done a wonderful work there, and in Punjab Haryana High Court, which I think his contribution can be shared by Dr. Balram Gupta by collecting those things and sharing with the Motor Accident Claims Tribunal, so that this jurisprudence develops this further to the next level. So I think I have completed my time, and I think I'm feeling very happy to share my knowledge with all of you. And this is a work which started in 2009 and completed in 2022. And total about, there are about, if you see the judgments also, there are about more than 10 or 12 judgments in Rajesh Tyagi, where I kept on developing the law to the next stage. And the last stage, to my mind, is a perfect stage, which has been, and I'm very glad that the government accepted the suggestion and recommendation of the High Court and incorporated in the rules, which is very, very rare. I don't remember where the government or the parliament has accepted the judgment. I remember many ordinances and acts which they have passed to nullify the judgments of the Supreme Court, that I remember. But I don't remember where they have immediately. And although you see, I have in various jurisdictions given the recommendations. In a maintenance matters, I had framed a new scheme like this one in matrimonial maintenance matters, and I recommended to the government to incorporate in the rules, but it lost somewhere. In execution cases also I had laid down some new parameters and guidelines and recommended, but that also didn't see the light of the day. Even in landlord tenant also, HS Bedi, I laid down those new principles and recommended. So there are more than, I think, 10, 12 judgments where I developed the law and recommended, but those recommendations did not see the light of the day. But fortunately, here in a very short time, the parliament and the government has accepted the recommendation, and this will go in a long way, and it will revolutionize the motor accident claim jurisprudence all over the country. With this, I'll thank Dr. Gupta once again, Shalini and Dr. Shergill also, and the resource persons also. Mr. Vikas Pava, senior advocate, is there, who represented Delhi Police, who was amicus and gave very valuable suggestions. Mr. S.P. Jain, who represented the insurance companies also in that fast DAR scheme, is also here. Mr. Kamaljeet Arora is also here, who had done a great contribution in the development of this law. And in large number of cases, I had sent the matter to service authority. I said, when my time was going up and so many matters were there, so I completed the judgment and said the other things will be looked into by legal service authority. And many of the cases he had decided in a very path-breaking manner. Thank you very much to all of you.
Thank you, Justice Midda. What an open heart surgery over this new scheme, which you have really authored and executed now, executing the entire scheme for that matter. The last 1.5 hours has been so meaningful in understanding the entire scheme, in developing the new jurisprudence, which is the effort which has been put in by Justice Mehta in this particular context. I assured Justice Mehta that we would do the monthly reports which are to be submitted to the Honorable High Court of Punjab and Haryana, and other aspects would also be taken care for this particular purpose. Thank you so much once again to be with us, and your blessings for this particular workshop. Kind of you for that.
Thank you.
Thank you so much. Good morning. We are now in for the second session, which pertains to duties of police under the new scheme. And for this particular session, we have with us Mr. Vikas Pava, the senior advocate. You know, to have a senior advocate, and that too of the stature of Mr. Vikas Pava, for a program of this kind is something, a kind of an achievement itself. A third generation criminal law lawyer started his career in the year 1993. And at the age of 42, he was designated a senior advocate. And in the field of criminal law, you name a particular case as such where he has not been engaged or has not contributed meaningfully, successfully as such. He is so much in demand in this particular field. The criminal jurisprudence, he has been a part of it, developing it in such a manner. And particularly this, his focus into that, his competent persons who would richly contribute. Yes. And request
Good morning. Am I audible? I'm sorry. I think there is a problem in the audio, so therefore I missed what Dr. Balram Gupta said in the end. Have I been told to start my talk today, or I just missed the last few minutes?
and sharing with everyone
Yes, sir.
how difficult it is for a senior advocate to spend time for a workshop of this kind.
Yeah.
And therefore, I'm doubly grateful to you that you spared the time and you're contributing effectively into this particular. May I request you to kindly.
Thank you. Thank you, Dr. Balram Gupta, Director of Chandigarh Judicial Academy, for inviting me today to speak on something which is so unique. It is my proud privilege and honor to speak about the motor accident claim under Central Motor Vehicle Amendment Rules 2022, which have been framed by the government recently. And why I immediately agreed to speak on this is because of my long association with this case. And so, if I may be permitted to say that these rules today are possible only because of single person's effort. And the way Justice Midha cultivated this case since 2008-2009. And if we see the judgment of Rajesh Tyagi, the matter belongs to the year 2003, but it actually picked up the speed in 2008-2009. The date of his elevation, he was elevated on 11th of April 2008. And if we see the judgments and the orders which have been passed and how Rajesh Tyagi 1, Rajesh Tyagi 2 and Rajesh Tyagi 3 came. Sir, am I audible? Is everybody can hear me?
Yes, sir.
Sir.
Right. So I was just narrating, the history to these rules. Normally, when the rules are framed, a statute is, introduced by the parliament, then there is a legislative history, which is important to, analyze. Now, in these rules which have been notified, there's hardly any legislative history, but there is a long judicial history. So therefore, since 2008-2009, Justice Midha, when took over this appeal of Rajesh Tyagi, we saw that series of orders were passed and how those series of orders have resulted into various rules and various agreed procedures. It started in 2009 on 16 December 2009 when this claim tribunal agreed procedure was envisaged by the court, and then how they were implemented by the Delhi police. It has a 4-5 minutes on it just to apprise everyone how this all started. And then, of course, I will discuss how the investigating agency was introduced in this entire procedure. So conventionally, if we see, the motor accident claim tribunals used to work on their own. I'm talking about prior to 2008-2009. The procedure which was followed was procedure under the Act. The tribunal used to try the cases, and it used to take about 10 years for a case to be decided, and then the compensation or claims are decided, given to the victims. But now you will see how the procedure has been changed and how the element of investigation is also imbibed into this entire procedure. How the investigating agency is also brought, because there is certain evidence which is not in possession of the victims and the tribunal. So how in a very, very intelligent manner, how an agency is being used to make sure that the claims are decided at the earliest and the victims paid, normally in a short period of time are paid and they are compensated for their losses. So I must share that in 2009, when this entire process started, I was the additional standing counsel of Delhi Police, and my Lord Justice Midha was handling this matter, and I was given the brief to appear before his court and to represent Delhi Police. There, this entire effort started, and Justice Midha envisaged this process and involved the Delhi police, and also openly said that we can't achieve this unless and until the investigating agency is brought into this entire process of inquiry. was formulated, where the whole objective was that the victim should get the compensation within 90 to 120 days. And then the Delhi police took up, this process and agreed that they will work on it pursuant to various orders which were passed by the court. And then they prepared a manual among the various officials as well as the legal department, and it was also put before the court. When it was put before the court also had a look at it, and Justice Midha affirmed it and said that, well, it is very nicely prepared and let us see how this pilot project can work. And it is only pursuant to the direction passed by Justice Midha that this process started, and it went on for many years. In 2010, 2011, 12, 13, many orders have been passed. And then subsequently, when it was noticed that there are certain lacunas in the scheme, then this Rajesh Tyagi 2 was introduced and certain modifications were made. And ultimately in 2018, Rajesh Tyagi 3 came, and then some more modifications were made. So this process, which started in 2008, actually got concluded in 2021. So I must say that during this entire tenure of Justice Midha, right from 2008 to 2021, one of the major energy which was focused was in this process, which ultimately was noticed by the Honorable Supreme Court. The Honorable Supreme Court also passed various directions where the Honorable Supreme Court said this is one of the best procedures they have ever seen, and then it should be formulated and it should be accepted by other states. So directions were passed, the committees were constituted, a lot of hard work has gone into all this. So in 2020, when the Delhi High Court Justice Midha saw that, yes, although the ball has been set rolling, but there are certain requirements, there are certain legislative requirements, because it has to be legislated, the rules have to be framed. Then I think last couple of years of his life as a judicial officer, as a judge of the Honorable High Court, he focused so much of energy into this and, introduced, called a lot of amicus curiae. I was part of it, and various other, very senior renowned lawyers were also part of it. And then this agreed procedure was formulated, and ultimately it was given a shape and a judgment has been passed. And that judgment was passed on 8th of January 2022. So a lot of hard work, a lot of comprehensive study which has been made by various quarters, the Transport Department, the Honorable Judge, and the stakeholders, everybody is heard, the insurance companies were also heard, and ultimately this judgment has come, which is one of the most remarkable judgments I've ever seen in my life. And that is why I said in the beginning that this is one set of rules which doesn't have a very comprehensive legislative history. It has a judicial history. So it's a great reading. I must request everyone to read it very, very carefully, the judgment, how it all started and how these forms were prepared. And the forms, again, each and every form, there are about, I think, 15, 16 forms. Each of these forms have been discussed threadbare. Each and every form was discussed and said that whether there's any violation of any constitutional right or not. So total are 19. There are 19 forms in this entire scheme. So when the forms were discussed in the court, were looked into, the procedural rights were looked into, Motor Vehicle Act was looked into, CRPC was looked into, Evidence Acts was looked into, and IPC was also looked into. Each and every law, which is probably done in the parliament, is done in the court in this case. And then each and every the requirement of the form was discussed and we all made sure that the forms should not violate any constitutional provision or any law. It should not be ultra vires, to any statute. And we are so happy to see that with this, commendable effort of Justice Midha, we have come up with a document which does not violate any law at all. So a great study has been done. And now, since my duty today is to primarily talk about the intervention of the police authorities, the investigating agencies, and what all they need to do. So it's very important that we understand what their duties are. the investigating agency should understand, the judicial officers should understand, the insurance company also should understand, and of course the victim and the accused person. So what has been done, what is unique about this case is how the investigating agency has been merged with the tribunal. How the powers which are given in CRPC have been very intelligently used to make sure that this entire process of compensation is concluded in the most reasonable period of time. And we have seen in the judgment and also in the procedure that the outer limit is 1 year. So see how the investigating agency is. Now, if we presume for the sake of argument that an accident has taken place, somewhere on the road, obviously the first person who reaches the spot is the investigating officer, because always invariably a call is made to 100 number, a call is made to the local police station. So investigating officer reaches the spot. Now, please compare and see how those forms are prepared. Now, those forms are so comprehensive that even an investigating officer who's not very intelligent, who's not trained, but if he follows this procedure, if he sees that each and every part of those forms, those annexures are filled properly, then it's an automatic process. So these forms are so comprehensive that investigating officer who reaches the spot, who has to find an eyewitness to the accident, examine the vehicle and meets the driver of the vehicle, offending vehicle, and also has the power and has a duty towards the victim who's there, who's injured, to do everything which is required in the domain of investigation. So that entire part of investigation now has been encapsulated, and it is brought in the form of these reports, which are a part of procedure. So an effort was made to include the technology into this. Then in case there is a CCTV recording, the CCTV recording should be brought in case the drivers and victims are carrying a phone, then their locations, then their telephone conversation in case there are any, and in case the driver is under influence of alcohol, for instance, then his alcometer test will be done. All this is part of the entire procedure. So investigating officer who invariably has to do this and then file a charge sheet in the court will be doing not only the investigation for a criminal case, but will also be assisting the tribunal for the purposes of compensation. So in any case, he has to do this job. It is not that his statutory duty was only to file charge sheet in the court. Now his statutory duty is also to assist the tribunal. So the first, in case we see the duties of the investigating officer and the process which is given in the, in the judgment, the scheme which is given, which is at page number 9 of the annexure, 9 of 109, there the entire process, the duties of the investigating officer is. So an investigating officer is duty bound now to file a first accident report within 48 hours. So within 48 hours, which according to me is more than enough, because CRPC itself gives the time frame of 24 hours. Here he has been given 24 plus 24 hours. So 2 days to conclude the preliminary investigation. And in any case, I as a criminal lawyer feel that preliminary inquiry is more than enough. You don't need 10 days, 20 days, or maybe a month. So 48 hours have been prescribed here, reasonably. According to our understanding, it's reasonable, of course, subject to the enhancement of time, which of course the provision is there in the scheme, that in case the IO is unable to do it, then he can always ask for extension from the tribunal. But first accident report is prepared. Within 48 hours, it is given to the tribunal, it is given to the driver, it is given to the owner of the vehicle, it is given to the victim, it is also given to the legal aid society, the association, because they are very important part of this entire scheme. And also, wherever the police has a website, because now Delhi police at least has a website, so direction is given that please post it on that website. So see what the investigating agency or the stakeholders have achieved in 48 hours. preliminary investigation. Copies are sent to everyone. They all are aware of what has happened. They all are prima facie aware of who the victim is, who the accused is, who's responsible, how many vehicles were involved. All that information is readily available in 48 hours. So what a concept. I must compliment the concept again that in a shortest possible time, a major part of investigation which is available at the site is concluded and it is shared with all the stakeholders. Then you would see that the victims, of course, victim can be a person who's not an educated person. He can be, a pedestrian. He can be a cyclist. He can be on a scooter. So they are not aware of what their rights are. Now the investigating agency, the IO, has been made to inform each and every victim as to what their valuable rights are. So whatever the investigation has been conducted, what is the procedure which is now have become the rules, how they have to be communicated to the victims is also part of the investigating agency's duty. So conclude investigation in 48 hours, the investigation at the site, and also inform the victim. So major part is done. And then the driver and the car owners, they are very, very important part of this entire scheme. Now, very often, whenever there is a big car involved and there is a scooter involved, the natural reaction is that there must be a problem with the driver of the car because it's a bigger vehicle. So normally the tendency is to implicate them without even understanding as to who's responsible for the accident. Sometimes the pedestrians themselves are walking on the road, they are running on the road, the scooterist himself can be negligent. Of course, will be part of the investigation, but their information from them is also very important. Now, if driver is an accused or the vehicle owner is an accused, it becomes very difficult to elicit information from them. So I remember, Justice Midha was so cautious of framing these entire rules that he was very clear that please make sure that the constitutional rights of protection given under Article 21 or Article 20 Clause 3 should not be violated. So those forms which have been prepared are forms which have been prepared after taking into consideration the protection which is given to an accused. They have been told to provide it. So normally, if we go back and see how the tribunal used to function, this information which now is coming in 10 days or 30 days before the tribunal used to take about years. Because in about 2 to 3 years, I remember as a young lawyer, we always used to wait for even the summons to be served on the respective parties. Forget about the investigation and the inquiry. And whenever we used to make an application before the tribunal to ask for the charge sheet which is already filed, the tribunal was reluctant because tribunal was of the view that I have to conduct my own inquiry and investigation. Why should I call a report from the police? But see how these two agencies have been merged very beautifully, where they all feel that yes, they are part of the criminal justice system and the system, the judicial system of grant of compensation, and how they have to perform their respective duties. So in 30 days now, what the tribunal has achieved is the first accident report, the driver's form, the owner's form, and then also the rights of victim have been communicated to them. So major work is already done. And in 50 days time, the IO, who's now seized off with the entire matter, will also give an interim accident report. Now, this report is very, very important to form a general opinion about what is happening at the investigation level. So this interim accident report is also given to the tribunal within, say, about 50 days. Again, to the driver, to the owner of the vehicle, the victim, the insurance company, and all the stakeholders who are involved. So within 50 days, the investigation is almost concluded. Now, very significant part of this entire scheme will emerge now, where the Honorable Court has very, beautifully merged the investigation and the final report, which is called detailed accident report. So 60 days period is given to the investigating agency to complete their investigation with regard to any criminal offense. When there's an accident which happens and, somebody dies, so offense under 304A is made out. If somebody's hurt, grievously hurt, then 337, 338 is made out, and all those offences are there, and also offences under the Motor Vehicle Act. Now see the advantage of these rules now. Advantage is not only the tribunal is getting the report within 60 days, it is also the criminal court which is now getting the investigation report under 173. So how an effective and efficacious system is adopted here, that both the investigation and the tribunal work is very expeditiously performed and reports are there in the court. Otherwise, I remember in 304A cases, very often, very often, because 304A cases normally or maybe an assistant sub-inspector who has a lot of work to do, who has a law and order problem, the duties to perform, he has investigation duties to perform. Very often we see that 304A charge sheet are not filed before 1 or 2 years. Now, in this case, with the help of these rules, even the investigation gets expedited. Now, the IO's job now is not only to make sure that the victims are secured, but also to make sure that driver and the owner of the vehicle, they give relevant information, the investigation and the trial, and all this reaches the tribunal. Now, Form 6A and 6B, which are at page 45, and I must compliment the Honorable Judge that he has taken into consideration the comprehensive part of the victim. Now, victim, normally nobody does an inquiry, with regard to the legal heirs, what and their financial status, what is the impact of the accident onto the victims. The entire accident of the investigating agency. Now, in this case, this Form 6A and 6B, which are at page number 45, is prepared. If you see, the forms are so comprehensively prepared that each and every relevant information with regard to the victims is already present with the court. Under normal circumstances, the tribunal would have conducted an inquiry. Here, the IO is assisting the tribunal, and victims are the one who are providing this information to the investigating officer in advance. And if there is no anomaly found, if there are no aberrations in this information, then of course the tribunal can accept these forms as it is. Now, if you analyze Form 6A, you will see that not only the FIR and other details are mentioned, and also the detail with regard to accidents are mentioned, but also the information with regard to victims. Now, their financial dependency on the deceased is already reflected here in the form. The income of the deceased is mentioned, and how many children are there is mentioned. Name, age, gender, relation, and marital status of legal representative is also mentioned. So, in a case of injury, there is a different information. In case of death, there is a different information. Now, another very important aspect of the matter which you must see is, see the analytical power of the Honorable Court here, that they also realize that sometimes there are minors who are the only sole breadwinner, the father and the mother, maybe both of them die or one of them die. What is the condition of a child there? So this Form 6B is with regard to the legal rights of the minor children. This was also during the course of argument, this was also, deliberately done, and a very renowned, counsel who came in, filed an application on behalf of Bachpan Bachao Andolan and came up and said that you are doing such a wonderful job, but nobody is talking about minors. Then a comprehensive exercise again is done with regard to minors, and Form 6B is introduced, where of course the details of the minors are also given to the tribunal. So see how interim accident report, which is in 50 days, and finally the detailed accident report. If all these three reports coupled with the charge sheet or the final report, which we say under 173, is placed before the court, see the quantum of information, see the relevant information which is required for the purpose of trial is already there before the court and from all the stakeholders. So if I compare this exercise with the exercise of investigation under normal case of cheating, it's only the investigating officer who goes, collects information, records the statement, collect the evidence, oral and documentary, and then provide it to the court. See, this particular exercise is much more comprehensive than that, much more detailed than that. The investigating officer's own opinion is there, but in this system, in this entire process, which is envisaged so beautifully, all stakeholders are already providing their information and submitting to the court. So in my view, if this process is adopted, then I can at least say safely that 95% of cases can be solved without any dispute. Of course, there'll be certain disputes with regard to quantum. There'll be dispute with regard to certain facts which have been stated. But if everything goes normally, if it's a case of a normal accident where all things are transparent and provided to the tribunal in time, then tribunal will be able to release the money, pass an order with regard to compensation within 6 to 9 months. So if we see the entire exercise, now, of course, the IO also may face, certain difficulties. It's not that everybody will cooperate with the investigating officer. Now, see how those issues which can arise somewhere in future are also envisaged in this entire scheme. Now, the IO may face a situation where IO is not being cooperated. The driver is not cooperating. The owner says, I don't have the information and I can't give it to you in 48 hours. I can't give it to you in 50 days. Then what should the IO do? The investigating officer has an option, even in this scheme, to go to the tribunal. To go to the tribunal, file an application, tell the tribunal about the difficulties and take a judicial order. Sometimes the statutory power of the investigating officer is also not sufficient. Very often we see that investigating officers go to the court, take non-billable warrants, go to the court under 91, take an order for production of documents where the accused is not cooperating. 311, there are various provisions in CRPC which are normally used by investigating agency. Here again, that option is also available. If the investigating agency feels that their powers are not sufficient to extract information, then they can go to the tribunal and they can file an application, get an order, and then either search premises or tell the stakeholders to come and attend the proceeding in the tribunal. So that is also there. And of course, we are not saying that this scheme is so sacrosanct, then each and every case will function like this, and within this time frame everything will be over. There may be cases where the information is not available, genuinely not available. There may be information where the driver is from a far-flung area, or there may be a situation of hit and run, for instance, where somebody has hit the victim and has run away. And sometimes you don't have the wherewithal to start the investigation. You don't have any information. Sometimes we don't even have the eyewitnesses to an accident. Those cases, of course, cannot be concluded in 48 hours. They can't be concluded in 30 days. So when the IO feels that there's a peculiar case where information is not forthcoming, the IO can certainly go to the tribunal and seek extension. So in the investigating agency, in fact, I have told, not be changed in every case. But yes, if you want extension, go to the tribunal and seek extension. 23 report is concerned, although in this scheme, it is time bound, but in CRPC, there is no time limit. So ultimately, the time has to be sought from the tribunal. And of course, it has to be on justifiable reasons. There have to be some grounds on the basis of which the extension can be given. Now, imagine a situation where you don't have a driver. The license which is also fake and fabricated, what does the investigating agency do? Those are extreme cases where investigating agency has to perform its duty, statutory duty, investigate, and may also add sections with regard to forgery. The normal case, this was never done before. In fact, this is also, something which which was manifested during the course of argument, and Justice Midha was of the view that, look, there are cases where all these documents are forged, but then the forgery sections are not, invoked in this entire investigation. So here again, sufficient time was spent on this, and this situation was also analyzed, where we see that sometimes the transport departments are also involved in cases of forgery of driving licenses. We have people, in fact, recently I did a case of drunken driving where a child who's actually was less than 18 was driving, met with an accident, somebody died. When investigation was conducted, the investigating officer found he is carrying a license from some place in Manipur. Of course, when he is less than 18, there's a question of driving license. But we all know we live in a society where sometimes the parents don't understand what they are doing. They don't understand the ramification, the after effect of permitting their young child to drive the car on the road, and ultimately it ends up in an accident. So there, these fake and fabricated driving licenses are also part of investigation. So IO, of course, has an option to include the sections of forgery, include the section of other offences under Indian Penal Code with the investigation of 304 and file charge sheet in the court. So that is also there. So if we see, if you have this judgment, then page 35 of the judgment is that flow chart. In fact, anybody who has already read it or who wants to understand, for him, the moment he looks at the flow chart, he will understand what this entire scheme is all about. And it is so beautifully framed by the Honorable Court that each and every timeline is mentioned, each and every duty of the department, whether it's the insurance company, whether it is the investigating officer, whether it is a tribunal, it is specifically mentioned here. So at a glance, this is the best chart which gives you an at a glance view of the entire scheme. There are so many schemes which are in circulation, which are also formulated by the government, but they are so difficult to comprehend. But here the scheme is so beautifully framed that it is so easy to understand. Just one page, if the investigating officer clips the page on the board in front of him in his office, he can just follow, and he will see that if he follows this scrupulously, the investigation is automatic. But last but not the least, I must say that these are cases which should be investigated by investigating agencies, and the officers who are deputed, they should be trained officials. And also the tribunal, the honorable judges who are posted in those tribunals, they should also be trained to make sure that how to deal with this. These are cases which have to be dealt with a lot of sensitiveness, with a lot of the compliances have to be seen, the timeline has to be seen, so it has to be scrupulously followed. So training to the investigating agency, to the officers concerned, training to the tribunal, training to the insurance company officials. Now, insurance company officials in this case have a role to play. It's not necessary that they have to object. It's not necessary they have to challenge each and every investigation. That is why if you see this chart right in the bottom, there are 3 columns which are mentioned. First is, if everybody says that yes, calculation is good, we have seen it, investigation is in accordance with law, all facts are relevant, we are not disputing, then a consent award is passed. And minimum time for that consent award, in my view, according to chart, is 6 months. So I don't think anywhere in the world you can get a system where within 2 months, the insurance company releases the check to the credit of the victim. This can happen only here in India if we follow the scheme very, very scrupulously. Similarly, if there may be instances where the insurance company may not agree on quantum, but may agree on the facts of the case. Insurance company may say everything is fine, we accept the report, we accept all 3 reports filed by the investigating officer, but we are not very happy with the compensation. I think it is too steep, or it is exorbitant. Then, of course, an opportunity is given to both the sides. They can file their written submissions, they can challenge, and there, of course, additional 3 months are given to the tribunal to decide those cases. So 6 months for a consent award, 9 months for an award where only the quantum is in dispute, rest things are accepted by all the parties. And third situation, which is envisaged, where of course everything is disputed, there again I think the Honorable Court has put up a timeline that if you challenge everything, if all facts are challenged, all reports are challenged, and everything is challenged in the court of law, then in 1 year you should conclude everything. So see a situation where IO concludes the investigation, file all the 3 reports, and in 90 days, and there is a dispute in quantum, then still the tribunal has at least 6 to 7 months to decide, which in my view is more than enough. And one thing which, of course, I must say beyond the scheme is that we must equip our courts with technology. If we equip our courts with technology, if the technological services are available, if computers are available, then we will see even this time frame can be reduced. I remember doing a trial in Greece, I think about 3-4 years back, where in the trial, when we went and we saw, the trial courtroom, we realized that every felony trial in Greece is conducted by at least 3 judges. So anything which is punishable for more than 5 years, which according to us, like we have offences which are triable by sessions court, there are offences triable by magistrate court, there are quantum of sentence involved. In that part of the world, anything above 5 trials is conducted by 3 judges. So the likelihood of mistake, the likelihood of any anomaly in the trial is reduced because there are at least opinion of 3 judges. So we can see in our country also that something like this can be formulated. But second most important part which I want to share with you all is the use of technology. So when we went and we started the trial, of course, my job was to assist the local lawyer, who was a Greek lawyer, is that at least 22 witnesses on that day in had a mic, the prosecutor had a mic, the complainant lawyer had a mic, and the accused lawyer also had a mic, and the witness also has a mic. So witness is called, witness comes, he starts giving deposition, and the cross-examination starts. There is no typing happening. There is no deposition which is being recorded by hand. It's only digitally recorded. And at least 15 to 17 witnesses examined in less than 4 to 5 hours. And all those witnesses who were examined digitally in the evening or maybe after 24 hours, the recording is given to each and every party. And later on, the transcripts were prepared. So imagine a situation like Greece in India, where this entire process, which is happening, where timeline is given 48 hours, etc. All this is digitally sent to the court. All this is respective parties. All this is recorded in the form of technology. And then orders are passed. I'm quite sure even this period of 6 months can be reduced, and the period of 9 months, 12 months can be further reduced. So in my view, this scheme, which is beautifully conceptualized, is used with technology. It can certainly be very, very effective. And I'm sure that victims in our country will be compensated in the shortest possible time. So this is in fact what I could read from the judgment and from the flowchart, and I could see that yes, this scheme can really work to the advantage of all the parties. The trials can be concluded at the earliest. All thanks goes to Justice Midha, who has conceptualized it, of course, with the help of some lawyers and the amicus curiae who were appointed, and also the stakeholders. But he has taken on his shoulder single-handedly. I have no qualms to say it. I must say it openly. It was his brainchild, started in 2009, concluded in 2021. And it has a great, great judicial history. It's very seldom we find cases which has a history of the court proceedings of more than 10 years. Out here, it has a history of more than 10 years, 11 years. And if we see how it has developed, it is remarkable. And we must pay compliment to Justice Midha for that. Unfortunately, I couldn't share the screen with him today, but I have no qualms to say, and he has done a great, great job. And the government, the Supreme Court has accepted this. In fact, Supreme Court has been accepting all the procedures which are envisaged by him. We have Rajesh Tyagi 1, we have Rajesh Tyagi 2, we have Rajesh Tyagi 3. Even the second one was accepted by the Honorable Supreme Court in the case of Jay Prakash versus National Insurance Company. And third, of course, is the most comprehensive, which is accepted by the Supreme Court. The DCP legal cell was available throughout. He cooperated, with the court and gave his full support. And we must say that Delhi police, right from day one, was open, was always. In fact, I remember interacting with the joint commissioners at that point of time in 2009. They never created any impediment in the formulation of the scheme. They always said, yes, we would like to do it. We want this system to improve. They were more than conscious about the delays which are happening, the touts which are there in this entire system. And if we use technology, I must add one more point to this, is if we add technology to this entire process, we will make sure that there are no fake claims. We make sure that there are no touts in between. Compensation for you in the court, and we will charge X amount of money. At least in India, that thing is not possible. And we can say that in India, that thing does not exist. With this kind of a procedure, we can also avoid that. And we can make sure that the victims get more than 100% of the payment which they deserve. So I think this is what I can add to what Justice Midha must have already said in the morning. And if investigating agencies cooperate, they follow this in its letter and spirit, I don't think there will be any problem. I don't think the police can say that this is a kind of a scheme which they can't follow. Even an ordinary investigating officer in the rural areas, if this scheme is given to him in a vernacular language, he can certainly perform very well and can be a great asset to this entire judicial system. So I can only say thank you so much. In case anybody wants to ask any question, any clarification, I'm open to it. I can answer them. In case there are any doubts, of course, Justice Midha was there, and we have Mr. Jain who will be coming. Mr. Jain played a very, very important role. Mr. Jain, who probably is the next speaker, is the person who deals with this day in and day out. He had such marvelous, practical, pragmatic knowledge about this procedure. His inputs were very nice and very valuable, I would say, for passing a judgment like this. So thank you so much, sir, for inviting me and giving me the opportunity.
Thank you, Mr. Vikas Pava. I know you have been a part of it at different levels and different stages and contributed in that particular process. And therefore you could share the entire aspect, particularly immigration aspect in such matters. You know, the investigation and further carrying out the entire trial for that matter. If it is expedited, it makes such a difference. And that is exactly the contribution which Justice Midha has made in this entire process. I remember my own days, how long it used to take the entire process. And a particular amount of compensation given, say 10 years back, look at it, the amount would be just nothing if it is not paid for another 10 years or 15 years for that matter. This is what is the jurisprudence now, which has been developed in this particular context. Thank you so much, Mr. Pava, to be with us, and we look forward to your contribution, particularly in this domain. Of course, your contribution in the field of criminal law is